On the 1st of July 2026, the United Kingdom quietly rolled out one of the biggest shifts in its entry and immigration policy in years. No big announcement, no countdown on the news. Just a date on a government webpage that most people never even saw. And right now, millions of people, travelers, visa holders, students, workers, families, trying to reunite, are walking straight into a wall they did not know existed. If you have any connection to the UK, whether you're planning to visit, you already hold a visa, or you have family living there, the next few minutes could save you from a nightmare you cannot afford to have. Welcome to UK Visa Diary, the channel that breaks down everything the system expects you to already know, but never actually tells you. Today, we are talking about the rule changes that came into effect on the 1st of July 2026, what they mean for you, and exactly what you need to do right now. Let us start with the most important thing. These are not minor technical adjustments. The changes that came into force on the 1st of July 2026 affect entry requirements at the border, digital travel authorization rules, visa conditions for multiple categories, and the way the UK Home Office processes and verifies applications. If you are thinking this only applies to people from certain countries, think again. Citizens from dozens of nations that previously enjoyed easy access to the UK are now required to go through new checks they have never had to deal with before. The first major change is the full enforcement of the Electronic Travel Authorization, or ETA, for a significantly expanded list of nationalities. The ETA system was introduced in stages, but as of July 1st, 2026, the scope has widened considerably. If you are from a country that was previously ETA exempt or had a grace period, that grace period is now over. Turning up at a UK airport, a port, or even the Eurostar terminal without a valid ETA means you will be denied boarding. Not delayed. Not questioned. Denied. The airline or transport operator is legally responsible for checking this before you even get on, so by the time you reach the border, it is already too late. The second change affects those already inside the UK. Conditions attached to various visa categories have been tightened. For people on work visas, the rules around switching employers, changing job titles within the same sponsor, or moving to a different region have become stricter. The Home Office now requires faster notification of certain changes, and some switches that were previously allowed within your visa period now need a fresh application. If you have changed jobs, changed roles, or are even thinking about it, you need to check whether your current visa still covers what you are doing. Getting this wrong does not just result in a fine. It can affect your entire immigration history and your ability to return to the UK in the future. The third area is student visas. Universities and colleges have been issued updated sponsorship compliance requirements, and the knock-on effect is that students in certain programs now face additional reporting obligations. More importantly, the rules around working hours during term time have been clarified in a way that actually narrows what was previously a gray area. Students who believed they were within their rights to work a certain number of hours may now find themselves technically in breach. This is not about intention. Immigration law does not care about intention. It cares about what the rules say on the date you did something. Family visas are the fourth category seeing significant impact. The financial thresholds for sponsoring a spouse or partner to come to the UK have been revised again. The income requirements are now higher than they were even 12 months ago. If you applied under the old thresholds and your circumstances have changed, or if you are planning a new application, you must use the updated figures. Submitting an application with outdated financial evidence is one of the most common reasons for refusals right now, and it is entirely avoidable. Visitor visas are also affected. The Home Office has issued new guidance on what counts as acceptable evidence of ties to your home country, meaning evidence that you intend to leave the UK after your visit. Bank statements, property ownership documents, and employment letters are being scrutinized differently than before. If you have had a visitor visa refused in the past and you are reapplying, you need to understand what changed and address it directly in your new application. So, what do you do right now? The first thing is to check your current status. Log into the UK Visas and Immigration portal and verify that your visa conditions match what you are currently doing. If anything has changed in your life, your job, your studies, your address, your marital status, cross-check it against the updated rules. The second thing is to check whether you need an ETA if you are traveling to or through the UK. Do not assume. Check. The ETA website is the official source, and the application is straightforward if you do it before you travel. The third thing is to seek advice if you are uncertain. There are regulated immigration advisors and solicitors who are qualified to help you understand your specific situation. Do not rely on social media, friends, or forums for immigration advice. The stakes are too high. At UK Visa Diary, we are going to be covering each of these changes in detail over the coming weeks. We will look at the ETA expansion country by country, walk through the updated work visa conditions, break down the new student rules, and explain the family visa threshold changes in plain language. If you do not want to miss any of that, subscribe now and turn on notifications so you are the first to know when a new video goes live. If this video helped you, share it with someone who is traveling to the UK, living there, or has family there. One share could genuinely save someone from a very serious mistake. This is UK Visa Diary, and we will see you in the next one.